So last class we discussed about up to now constitution, constitutionalism, constitutionality, then historical underpinnings of the constitution 1773 to 1947, then making of the constitution, what are all the boards, who are the heads of the committees who are responsible for the making of the original constitution. This all we discussed. And today also we discussed about salient provisions. We tried to remember the salient provisions of the constitution. What are all the salient provisions of the constitution? Today we will be discussing about the salient provisions of the constitutions and its applications. Application point of view, first static part, what are all the salient provisions, and then we will go for dynamic part also. So salient features of the constitution, though borrowed from every constitution of the world, it has several unique features that distinguishes it from other countries' constitutions, which distinguishes ourselves from, means what are all the good we took, what are all necessary we took. So this is the, so I told you in the last class there are important constitutional amendment acts like 7th, like 42nd, like 44th, 73rd, 74th, but the most important is 42nd. Why? Because it has 42nd Constitutional Amendment Act, which is made in the year 1976. Which is made in the year 1976. The 42nd Constitutional Amendment Act is most important because it had added so many provisions. It added so many provisions, it removed so many provisions. When I am going to discuss about the important Constitutional Amendment Act, first I will be discussing about 42nd only. So it added new provisions and removed old provisions. So because of this, 42nd Constitutional Amendment Act is considered as mini constitution of our constitution. In the Kesavananda Bharati case, one more concept came into existence. I told I will be discussing in a separate chapter called as basic structure doctrine. So the salient features of the constitution are, salient features of the constitution is, one and the foremost salient feature is lengthiest written constitution. Lengthiest written constitution. What is this lengthiest written constitution? What is this lengthiest written constitution? I will tell you. Last class also few students asked me what is the original meaning of codified constitution. So two types of constitutions will be there. One is called as written constitution, other is called as unwritten constitution. Some will be called as written constitution, some will be called as unwritten constitution. Written constitution means a book will be there. A separate exclusive book will be there. In that book, everything will be written properly, neatly in arranged format. So one exclusive book is dedicated for the constitution, or exclusive write-up or exclusive document is sacrificed for the constitution is called as codified written constitution. Everything is written properly. Everything is mentioned properly. What is meant by unwritten constitution, sir? Why? Because here we are going to, I am telling that it's the lengthiest written constitution. So everything is written in this particular book, and this book also weighs around 1000 pages. So all the provisions of the constitutions are present in this particular book. Hence it is called as written constitution. Written constitution means codified. Codified means which is written properly. Unwritten constitution means which is British constitution. Unwritten constitution bole to, there is no one specific book. There is no one specific book. For example, if you ask me what is Indian, I am a foreigner, I am an Indian, you are a foreigner, you asked me what is the constitution, then I will take this book and I will give you. But if you are from Britain and if you ask me, give me Britain constitution, I want to study. Give me Britain constitution, I want to study. Whereas Indians, when they ask what is your Indian constitution, I am giving you Indian constitution. But the same when the British people are asking for British constitution, I am unable to give in one particular format. There is no one particular document. There is no one particular file. So what I will tell, the laws which are made in the parliament, the judicial judgments which are made in the constitution, the judicial judgments which are made in the Supreme Court, this all together called as the Constitution of Britain. Means all are not arranged properly, all are not dumped together in one particular document. So these all are in the law form. This is the law for this, this is the law for this, this is the law for this, this is the law for this. It is not arranged in the form of a one proper book which is there from Article 1 to 395. But whereas in Britain, what happened, when I talk about the constitution, then I will ask, what do you want? Fundamental rights. Check that law. What do you want? I want what are the powers of Supreme Court of Britain. Check this law. What do you want? I want the information on how the capital city should be administered. Check this law. So these all are not brought together in one particular document. These all not brought together in one particular box. So if single box is there, it is called as codified written constitution. If it is haphazard, so we have to search, then it is called as uncodified unwritten. That is a major difference. Polity, anyhow, textbooks, 18 textbooks will be provided to you in the form of hard copies. But polity, this content, how I am giving you? I am giving you in the soft copy. I am giving you in the soft copy. So for what? For example, I gave for historical underpinnings, one document I gave. Constitution making, one document I gave. This salient features of salient features of the constitution, one document I gave. Now I asked you, give me your polity notes. Then what you will ask? Which topic you want? Unwritten, uncodified. So what? I am giving you unit wise. My intention is you have to study unit wise. And finally, what I will do when the polity subject is completed, I will accumulate all and I will be providing you one particular PDF. At that time, if I ask you, if you had this book type, then someone asked you, give me fundamental right. Whether you will give complete book and search, you will tell, or you will again only give fundamental right. So when you give like a complete codified material, it is called as written constitution. When you don't give in a one particular format, it is called as unwritten constitution. Then what you will tell? You want to talk about divorce? Then this. You want to talk about Election Commission of Britain? Then this. You want to talk about Comptroller Auditor General of Britain? Then this one. So in that way, if it is not arranged properly, it is called as unwritten. If it is arranged properly, it is called as written. Written means everything is dumped into one particular box or dumped into one particular book is called as codified written constitution. Original constitution have 395 articles, 22 parts and 8 schedules. I told you in the beginning. So this constitution, this book, written constitution, how many articles are there? 1, 2, 3, 4 like this. How many articles are there? Means 395 articles are there. How many modules are there? How many modules are there means parts. Here it is called as parts. And how many annexures are there means 8 schedules. I told you what is schedule also. Schedule means which are present in the form of an annexure in the final to check for reference. So the constitution has, original constitution in 1950 have 395 articles, 22 parts and 8 schedules. But lengthiest written constitution, it is subjected to lot of constitutional amendments acts. The constitution is changing with respect to time. With respect to time, it is adopting. For example, one example I will tell you. Article 21 of the constitution talks about, Article 21 is called as right to life and liberty. Article 21. In that what I did, I added one more article in 2002 and I added 21A and I told that those children age is from 6 to 14 years, they should be provided with free and compulsory education. Why they didn't add it in 1950? At the time they don't have that idea. At the time we don't have the resource to give free and compulsory education for all the children whose age is 6 to 14 years. So with respect to time, I am going updating, I am going adding, I am making it more dynamic. In that process, what is happening? The articles has increased up to 470 articles, the parts has increased up to 25 parts, and the schedules has been increased up to 12 schedules. Oh, so when the 1950 constitution was there, how many articles, how many parts, how many schedules are there? And by today, how many articles, how many schedules and how many parts are there? Means 25 parts, 12 schedules, 470 articles. Why there is a necessity for change, sir? Why those many articles has been increased? The correct answer is, with the time we are evolving. With time we are changing our constitution. For example, how we changed our law? LGBT communities. Section 377, once upon a time, unnatural sex was a criminal offence. Unnatural sex means a sex between a two male or a sex between a two female is called as unnatural sex. So now unnatural sex is not a criminal activity. But once upon a time, before 2017, it is a criminal activity. Means what? With respect to time, we are evolving. With respect to time, we are evolving. It is called as section 377. If you notice how I am adding example, so you should also evolve in the same way. So yes, constitution is changing, at the same time laws also changing. According to the time, the laws are changing. For example, what? The section 377, which was been allowing for unnatural, which was been a criminal when anyone follows unnatural sex, but now it got decriminalized. Means what? Now Indian society is accepting the relationship between the two males, the relationship between the two. Means with respect to we are changing, with respect to the change, laws are also. In the same way, the original constitution book also is getting changed. The constitution is also getting amended, because of which the article 395 became 4 factors of elephantine size. Why that much big? So if anyone asks you after the class, oh, so yours is a very lengthiest written constitution. Why that much lengthy your constitution? What made it? Number 1, we are having diverse geographical factors. We have desert area, we have peninsular India, we have desert area, we have peninsular India, we have deep denser forest, we are having mangroves here, we are having islands here, we are having hilly mountains here, we are having Shivalics here, we are having Eastern Ghats here, we are having Western Ghats here. States are diverse. Means the people are different, the geography is different. So every section of people, every section of community I have to address. So that means my constitution should be more diverse. When my constitution is more diverse, means the numbers will. One factor is geographical vastness or geographical diversity. Number 2, historically we have which act we are following. Before Constitution of India, we have Government of India Act of 1935. I told you half of the constitution is copied from Government of India Act of 1935. Means what? It is getting down. It is borrowed down. So how many provisions are there in Government of India? It is already bulkier. The bulkier came down into the Constitution of India. Means we copied from Government of India Act of 1935. Already Government of India Act of 1935 is bulkier. So the Constitution of India also became geographical variation. Number 2, historical. What is historical? We borrowed from Government of India Act of 1935, which is already a bulkier constitution. Single constitution. In America, 2 constitutions are there. One constitution for United States of America, another constitution for Texas, for Connecticut, for Chicago. For every state there is one constitution. So when I am making the constitution for United States of America, I will not bother about state. So the American constitution is thinner because for central one constitution is there, for state one constitution is there. Coming to India, what is happening? We have one particular constitution. Why? Because India is union of states, whereas America is agreement of states. And in their agreement, they written the condition. They written that we will have our own constitution. You have your own constitution. But in India is not agreement. It's a union. Union means voluntarily we came together and we formed India. You tell me, when as I told you earlier also, when the relationship is voluntarily by instinct, the relationship will be strong, or when the relationship is in a bond form, the relationship will be strong. When the relationship is voluntarily, instinct. So India that is the great, we are Union of India. Why? Because by instinct, by voluntary we came, and we have single constitution. States doesn't have their own constitution. So when I'm making constitution for India, in which nearly 30 states are there, now 29 states are there, what will happen? The size of the constitution will increase. So one is geographical variation, number 2 is historical factor, number 3 is single constitution, and number 4 is who dominated Constituent Assembly. What is Constituent Assembly? The assembly which is responsible for making of the constitution is called as Constituent Assembly. Which profession dominated Constituent Assembly? So when the lawyers are writing, what they will write in a flowery language, and one sentence, how we can cut short, the same sentence they will write in 4 or 5 sentences. So what is happening? Because of these legal luminaries who are present in the Constituent Assembly and who are responsible for the making of the constitution, the document size has been dominance of legal luminaries. So these are the 4 factors. prelims point of view, what are the factors which are responsible for the lengthiest written constitution means, number one, geographical variations, which is also called as diversity, geographical variation. Number two, historical reason. Most of them we borrowed from Government of India Act of 1935. Next is single constitution, and the next is legal luminaries. These are the four factors which are responsible for. There is one more concept which is called as barrister. There is a doubt, who were barristers? Barristers, I will tell you. First, you have to understand two concepts. If you do law, you will understand. Lawyer, prelims question. 2022 prelims question this is. What is the difference between a corporate lawyer as well as an advocate? I will tell you. See. Lawyer. Why? Because I am a bar counsel of Hyderabad High Court. Lawyer. We will use word lawyer. That is wrong word. Lawyer only makes document. Lawyer is expert in making agreements. Lawyer is expert in making petitions. But he will not argue in the court. Lawyer only makes the document. Lawyer only makes the agreement. Lawyer only makes the petitions. That's it. Advocate will argue in the court. Advocate will argue in the court. That is a major difference. Barrister, earlier we used to call as barrister. Barrister is similar to lawyer. Barrister is similar to lawyer. Who will be having the power to file a petition? That's it. Who will be having the power to write a document? It means he can file a petition, and if it's endorsed, it will become legal document. That is a major difference. Barrister is, at that time, the barristers were been, now the name of the barrister has been changed as lawyer. Okay, Akshay, who comes under public prosecutor? Public prosecutor means government advocate is called as public prosecutor. Means I am there. If, for example, I am public prosecutor, when I will be called as public prosecutor means a case happened. Police did encounter. Police did encounter means it's government. No, police are the government, means called as state. So a human rights activist had filed a case. This encounter is fake encounter. So he filed it. So from his behalf, compulsory one advocate will be there. But from government, one person should be there. No, that government advocate is called as, this is first salient feature is lengthiest written constitution. Ambedkar told, our constitution is copied constitution. But what we copied? We copied the best provisions of the constitutions of various countries, 60 countries. But when we are copying, we try to amend it. We try to change it. We try to alter it according to the local conditions of, so it is nothing but ransacking all the known constitutions of the world. I took all the known constitutions of the world and which are suitable for the Indian environment, which are suitable for the Indian conditions, I had added into that. Why? Because my major motto is protection of the liberty of the citizens of the country. So what are all good? I took from various, the most influential material or most copied is Government of India Act of Emergency Provisions. This Weimar Constitution means Germany's. Weimar Constitution means Germany's. So we borrowed from Weimar Constitution what? Emergency provisions. Today we have emergency provisions, no? When there is armed rebellion, when there is internal disturbance, when there is war from foreign countries, then there will be emergency like situation. So that emergency situation, if it is there, how the government should respond, how we should respond is copied from which constitution? Weimar Constitution. Weimar Constitution means Germany's constitution. Similarly, from Japan, we took what? Procedure established by law. Means everything should be according to the procedure established by the law. Means lower court, then high court, then Supreme Court. As per the procedure, we have to go. This procedure established by law, where we borrowed from? French. Republic, ideals of liberty, equality and fraternity, we borrowed from French. French is famous for what? Republic. French is famous for what? Equality. French is famous for what? It guarantees liberty. First, the word liberty, equality and republic came into existence from after Napoleon Wars, which you will be discussing in your world history. The outcome of French Revolution is republic, equality, liberty and fraternity, brotherly feeling. We borrowed from French. Remember the terms, you will get negative marking. Don't think this I know, not like that. Again, we have to focus. Republic, liberty, equality, fraternity from South Africa. Procedure for amendment and election of members to Rajya Sabha. amendment of the constitution is done under Article 368. Forget about the number. How to amend the constitution? We borrowed from whom? South African constitution. As well as election to the members of Rajya Sabha, means upper house. What should be the procedure for the election of Rajya Sabha? From where we borrowed? We borrowed from South African constitution. Two things. South Africa, what all? Constitutional amendment procedure. Number two is election procedure of USSR. At that time it is USSR, Union of Soviet Socialist Russia. 14 states combined together, 14 Soviets combined to form USSR. Now Ukraine, part of USSR, Georgia, part of USSR, Tajikistan, Kyrgyzstan, Turkmenistan, Uzbekistan, these all countries are part of USSR. So USSR was being divided into Russia and got 14 countries independence in the year 1991. So we made a constitution in 1995, 1950. So we borrowed from USSR or we borrowed from Russia? So what we borrowed from USSR? Fundamental duty, ideals of justice, social, economical and political in the preamble. We borrowed from the ideal of justice, social, political and economical, as well as fundamental duties. We borrowed from Australia. In Australia, what we borrowed? I told you dominion status. Australia is what today also? A dominion. It's a proper federal country. Means center is there, states are there. States there, it is called as provinces. Center is there, provinces is there. I told you. There is federal list, there is state list or provincial list. Federal list means only the federal government, means central government can make laws on those. Provincial list means only provincial government will be having the power to make the provincial list, federal list. Something new thing came into existence which is called as concurrent list. Means where federal government can make the law and the state government can also make the law. Means central government also can make the law. For example, this is central government, this is state. So what will happen? The central government will make law according to their wish. State government will make law according to their wish. So what I did, there should be certainty, clarity. These are the list 1, 2, 3, 4, 5. You central government, you can make law only on this. 1, 2, 3, 4, 5. Your state government, you can make law only this, like agriculture, like defense. But there are something which is important to both of them. Like what? Interstate trade. So goods which are coming from Maharashtra into Andhra Pradesh. The goods which are moving from Kerala to Tamil Nadu. So both the states are involved. So when I like, yes, you can sell in my state, no problem. In my state that goods are not there. But sometimes what will happen? Some states can also stop you. You should not come into my state. So for such issues, what they did, they made an innovation called as concurrent list. So central government can also make the law, state government can also make law. But state government law is inconsistent with the central government. If state government law on that subject which is present in the concurrent list, if the state government is in conflict with the concurrent list with the central government, then central government will prevail. Means if you both are there, you are central government, these are state government, this is concurrent list, and your state government made a law on this, and the central government also made the law on this, then there is a conflict. Both made a law. Whose law I should follow? People are asking. First you decide whose law I should follow, that law will follow. So the constitution told that sometimes that issues will come. So when there is a conflict on the concurrent list, this we copied from whom? Concurrent list we copied from Australia. Freedom of trade, commerce, intercourse. Intercourse means movement of the goods. And joint sitting of two houses, Lok Sabha and Rajya Sabha, we copied from. So from Australia, concurrent list. From Australia, freedom of trade, commerce and intercourse. And joint sitting of two houses. Lok Sabha, Rajya Sabha, both houses will sit together, no, sometimes, to solve some disputes. When there is a logjam, when the bill is not passing, when Lok Sabha passed but Rajya Sabha is not passing, when Rajya Sabha passed but Lok Sabha is not passing, then what they will do? They will make the two houses to sit. So where we copied this concept? Weimar Constitution what? Weimar Constitution what? Emergency. Japan Constitution what? Procedure established by the law. French what? Republic. Terms are very important. Liberty, equality, fraternity. South Africa what? Procedure of amendment of the constitution as well as election to the USSR what? fundamental duties. And next what? Ideals of justice, social, economical and political. Australia, what we copied? Concurrent list. As well as trade, commerce, intercourse also we copied from Australia. And the joint sitting of two houses. These are we copied from other constitutions. At one place, Government of India Act of 1935. Federal scheme means from Government of India, we followed federal scheme. What is federal scheme? There will be a central government, there will be a state government. We followed this federal scheme from which? Government of India Act of 1935. Office of Governor. There, for every province there will be a governor. For every province there will be a governor, and the governor will be the final responsibility of the province's affairs. Office of Governor. Judiciary. If you remember, judiciary, 1935 Government of India Supreme Court came into existence in 1935 on the law of Government of India Act of 1935. So judiciary also we copied from Government of India. Public Service Commission. There is a Federal Public Service Commission, Provincial Public Service Commission, Joint Public Service Commission, copied from. Emergency provisions. Very good question. Understand this. Sir, now only understand this. Sir, now only you told emergency provisions is taken from Weimar Constitution, and here you are mentioning emergency provisions is copied from Government of India Act of 1930. Emergency provision we took from Government of India Act of 1935. But when emergency is in force, there will be suspension of fundamental rights. I will tell you when I am discussing fundamental rights. Means what? If emergency is there, everywhere chaos is there, then what the government will tell? No more fundamental rights. People cannot move according to your wish. People cannot speak according to your wish. People cannot have free of speech and expression. So everything is suspended. Why? Because then only the law and order will come into. So what I did? I violated or I suspended some of the fundamental rights. So suspension of fundamental rights when emergency in force is Weimar Constitution, complete emergency provisions from Government of India Act of 1935. Again, a very important clarity this is. So in Weimar Constitution, emergency provisions when the fundamental rights got suspended. So emergency provision is there. What the government, when the government will put emergency provision when situation is not under, like from 1976 to 1977, when Indira Gandhi has imposed national emergency under internal disturbance, 2 years we are suffered with emergency, national emergency. Everywhere across India, people cannot walk easily on the road, people cannot speak whatever they want, people cannot give interviews, people are totally controlled. Means complete fundamental rights, basic rights are been suspended. Why? To make the society into normal situations. Why? Because there is a, so this suspension of fundamental rights in order to bring law and order back is copied from which constitution? Weimar Constitution. And other provisions means just emergency provisions I copied from. So emergency provisions from Government of India Act. At the emergency, if there is, at the time of emergency, if there is violation of suspension of fundamental rights, it is borrowed from administrative defense. How we have to run the administration. Everything is copied from Government of India Act of 1935. Functioning of the administration is also copied from Government of India Act. Next. From British, what we copied? British. Directly from British. They also have parliamentary form of government. We also have parliamentary form of government. Our government is parliament only. No? Who is having the majority in the parliament? That party will form the government. So parliamentary government is copied from British. There is something called as prerogative writs. Prerogative writs or prerogative writs means police came suddenly and told that you should not walk on the road. Why? There is no section 144, there is no emergency, there is no curfew, everything is normal, I am walking on the road, what is the problem for you? No, only you should not walk. Then I have the right to go to Supreme Court and file a petition. That petition is called as prerogative writs. When any individual fundamental rights is violated, he have the power to go to Supreme Court and get his rights back. So getting his rights back, when I fight for my fundamental rights, then the petition, I will not use word called as petition at that context. I will use a word for the petition called as. So writ is not anything, writ is just a petition, but when I give a petition for my protection of fundamental rights. At that time, the petition is called as prerogative writ, means fundamental right is my privilege. So you are removing my privilege, so I want my prerogative, means what I lost, I want it. Prerogative writs which we copied from, means what? Fundamental rights are the basic. No, walking on the road is a basic. So if someone stops me, means my fundamental rights is violated. So in order to get back my privilege in the form of basic fundamental rights, I will be filing a writ petition. That writ petition is called as bicameralism. In British also, bicameral means two houses. Just remember, bicameral means two houses. How we have Lok Sabha and Rajya Sabha. Lok Sabha is called as lower house and Rajya Sabha is called as upper house. In state also we have two houses. One is called as Legislative Assembly, other is called as Legislative Council. So in the states also there are two houses. One is Legislative Assembly, other is Legislative Council. The member of Legislative Assembly is called as MLA. The member of Legislative Council is called as MLC. The member of Lok Sabha and the member of Rajya Sabha both are called as MPs, but MP of Lok Sabha, MP of... But here in state it is called as MLA and MLC. Legislative Assembly and Legislative Council. So this model of bicameralism I copied from legislative procedure. Next, legislative procedure. The passing of the bill. How a bill will pass? How means the government will come with a bill and they will put in the Lok Sabha. So Lok Sabha people will look into it, argue into it and give some decisions or make some decisions, give some advices, then they will pass. Then again it will go to Rajya Sabha. In Rajya Sabha also they will discuss, they will give some decisions, they will make some advices, they will pass. So when the two houses are passed, then the Lok Sabha and the Rajya Sabha bill will go to the president and the president will keep his signature. Hence, then bill will become act. So other names for act, remember forever. Other name for acts is legislative. Other name for act, statutory. So when a bill is passed, it is called as legislation. When a bill is passed, it is called as statutory. When a bill is passed, it is called as act. It can be called as act. It can be called as statutory. It can be called as... So the procedure of making the law, the legislative procedure is copied from which? Single citizenship. We have, India we have citizenship for India and citizenship for Andhra Pradesh. Citizenship for India and citizenship for Kerala? No. We have only one citizenship. So this single citizenship we copied from whom? British. Why? Because America have dual citizenship. So we copied what? Single citizenship. Of which country? Cabinet system. We have cabinet system. What is cabinet system? There will be a home minister, there will be a finance minister, there will be a defense minister, there will be a transport minister. This close ministers of the prime minister is called as cabinet system, which we borrowed from Britain. Rule of law. There is something called as rule of law. Everyone should follow rule of law. There is a law and the law is final. Means what? If you go to North Korea, there is one particular fat man called as Kim Jong-un. So what this King Kong will tell, whatever is coming from his mouth is a law. If you tell them go and give him death penalty, means they will give. They will also give. Go and kill him means they will kill. If not, he will only remove some stages, people will fall down. Means he himself became so much powerful. Why? Because the country is today also ruling like a dynasty. Today also the North Korea is ruling like how it was in the Delhi Sultanate time period. How it was in the medieval India. Today also North Korea is like a kingdom. So whatever the king is telling is, but what I am telling you, in India we have rule of law. No one is above the rule of law. It might the Prime Minister of India also should follow. So from where we got this, you should get one doubt. Sir, what is rule of law? Where it is? Procedure established by law. Where is procedure established by law? We copied procedure established by law from Japan. I will tell you. Rule of law means just a statement. Any one person's words or any one person's discretion will not be called as law. There will be a written thing, either in one particular codified form or in different forms. But everyone should follow that. So when we are following one particular rules and regulations book, there will be clarity or not. So that rules and regulations which are in the form of a written, it is called as rule of law. Procedure established means it is not only about rule of law, it is also about following the rule of law. Yes or no? So whether morning 8 o'clock, morning 6 o'clock I will get up, then I will study from 6 to 8, then I will do breakfast, then I will go for again library or reading room, I will study up to 1 o'clock, then 1 o'clock to 2 I will eat, then 2 to 5 I will study, and like 11 o'clock, 12 o'clock I will sleep, next day finish. You got up at 10 o'clock. So it is not about rule of law, it is about what? Following the rule of law. So following the rule of law is procedure. We are following the procedure. We are following what is present exactly without any deviation is called as following a procedure established by the law. So this follow-up is of Japan, and the rule of law which is written is parliamentary privileges. Sometimes MPs will not be arrested in the parliament. MPs will not be arrested when the parliamentary session is happening. You will come to know, I will tell with examples. So some MPs will have some privileges. When they are in the parliament, police cannot go and arrest him. When a parliamentary session is also happening, a police cannot arrest him. So some privileges are there. He can travel every month to and fro, free flight tickets. He will be given with 4 employees to work under him. The payment will be made by the government. He will be paid with 4 home guards who will be guarding him every time, like security guards. So these all salaries will be paid by whom? The government. These all are what? Parliamentary privileges for the parliamentarians. This we copied from whom? Britain. So parliament, Britain. Parliamentary. Prerogative, bicameralism, legislative procedure, single citizenship, cabinet system, rule of law, parliamentary privileges. This is very important table for prelims. It seems like we know, but we cannot believe. So repeatedly we have to remember. Sir, here Judiciary Government of India Act, but here it is independent judiciary. Here the judiciary of 1935 is influenced by the judiciary model of what? Supreme Court, High Court, District Courts. We copied from Government of India Act of 1935. But the independent functioning of the judiciary is copied from? Independently they have to give the judgments. They should not be under the control of any parliament. They should not be under the control of any prime minister. They should not be under the control of any money. They have to give the judgments independently. So the judiciary, you see, if it's not the judiciary which is great, it is not the Supreme Court, it is great. In India, the Supreme Court is great because it is functioning. If you become an IAS officer, you will not become great. If you become an IAS officer, after the results, the 3 months will be total Allah will be there first 3 months. Then again you will become a common man. You will go like a training. You will go like a student. You will sit at there. You will be a common man. Again, when you come here, everyone again they will see. But finally, you will become a common man. But so that IAS is a common thing. But when it will become popular means when you work independent, when you work unbiased, when you work without any extra money, when you work with genuineness, then that particular position will get named like Ashok Kemka, Shankaran. So in the same way, what I want to tell you means the structure is taken from Government of India, but the independent functioning is taken from, it's called as Bill of Rights. The fundamental rights are present in American Constitution by the name called as Bill of Rights. We had adopted as it is from which country? America. So fundamental rights are drawn from America. Judicial review. Sometimes state government or central government can make a law. Sometimes state government and central government can make a law. For example, now BJP ruled state like Karnataka, they made a pass. They made a law. Now onwards, Karnataka state is called as Hindu Rashtra, Hindu state. Only Hindus should be given all the jobs. But what the constitution is telling? What the secular. So now immediately the judiciary will come and judiciary will review the law made by the Karnataka Assembly and it will tell that this particular law is unconstitutional. It is violation of constitutional provisions. Hence this law is null and void. So this judicial review we copied from President impeachment. Donald Trump got impeached. So this procedure of Donald Trump or the procedure of impeachment, our president also. How we will be impeaching the president? There is some special majority which is passed in Lok Sabha. I will tell you when I am discussing about president. There is special majority in Rajya Sabha. When it is passed, then the president will be subjected to removal. So this procedure we copied from whom? USA. So the president impeachment. Impeachment means removal procedure. The word impeachment means removal procedure. So the removal procedure of president we copied from removal of Supreme Court and High Court judges. If any Supreme Court judge and High Court judge itself are corrupted, who should act independently, they themselves are not acting independently. There is a clear-cut evidence that he is taking money from one of the petitioner. Then how I have to remove the Supreme Court and High Court judges? The same procedure is present in America. The same procedure we adopted here. So the removal of Supreme Court judge and High Court judge in India is copied from post of Vice President. Post of Vice President. India also the post of Vice President is there. In America also the post of Vice President. Here also the Vice President will be waiting for sudden dismissal of the President. Then only he can become President, at least for 6 months. Within 6 months they have to conduct elections. There also the Vice President will be happening. Now something is going on, do you know, in American politics? Have you noticed in American politics what happened? This Biden and Kamala Harris is the Vice President. They are not talking with each other. Like we people, how we fight, they are fighting now. They are not. Kamala Harris came on video, is there out. The Kamala Harris came, so the Biden rotated. He don't want to see her face. President and Vice President. Means now what? Kamala Harris will go home and she will talk with her husband. When this old fellow will die, then I will become president. If it is Telugu movie, what he will do? The Vice President will make a supari and he will kill. Then he will become Vice President. So who is that supari person? This inquiry will happen. So for every, whereas in American movie, what? American movie, someone, one Rambo will be there who will be protecting the president. So this removal of role of Vice President we took from next Ireland, DPSP, Directive Principles of State Policy. Directive Principles of State Policy. DPSP. Directive Principles of State Policy. What is this means? As I told you earlier also, directions given to the state while making policies. What are the directions? In the form of principles. So directions in the form of principles given to the state for the formation of. So the constitution is telling that you central government, you state government people, you no need to worry. You don't need to break your heads how to make policy, how best to make the policy. Already I know it is present in the constitution. In which provision? Directive Principles of State Policy. You just implement it. So this Directive Principles of State Policy which is present in our constitution is already present in Irish. So we copied from Irish constitution. Next, nomination of members to Rajya Sabha. Nominated members will be there, elected members will be there in Rajya Sabha. You have this knowledge, I know. Elected members will be there, nominated members. So this nomination members to the Rajya Sabha is borrowed from Irish. And election procedure for Rajya Sabha members is taken from. Election procedure of Rajya Sabha members is borrowed from South Africa. Nomination members of Rajya Sabha is with which procedure? Irish procedure. Method of election of president. This is method of election of. This is what? Removal of impeachment of president. How to remove is from USA. How to elect Irish. So method and election of president is from Irish. Next, coming to Canada. Canada is a very good example. Canada is a very good example. Why? Because Canada is very huge. Northern America. North of USA is Canada. So this Canada is a pure example of federation. Canada is a pure example of federation. Means what, sir? So there will be a central government. There will be a provincial government. Don't get confused. Provinces is also called as states. In some countries they will call it as state. In some countries they will call it as, in Japan those are called as cantons. In India it is called as states. In Canada those are called as provinces. Federation means a clear-cut central government and a clear-cut state government, or a clear-cut central government, A clear-cut provincial government means this provincial government will be doing laws and will be implementing the laws with respect to that province, and this central government will be doing with respect to complete country. So this model of federation and this model of province, this model of federal government, this model of provincial government, we copied from Canada with a strong center. So federation system is copied from Canada, and it tells that in Canada, central government is more powerful than state governments. But in USA it is called as federal government, which is sitting in Washington. If there is any conflict between the Washington and any state, 50 states are there now in USA. If there is any conflict with any state, federal government is not supreme, means central government is not supreme. So the state government also have the equal power with central. But in India, as well as in Canada, we are federation. We also have state government with strong you people, all India service officers, IAS, IPS, Indian Forest Service officers. You are central government employees or state government employees? Central government employees. You are being recruited by central government, but your posting is in state. Why your posting is in state? Your posting should be in central government only. No, it's a system which is created, which is called as all India services, so that the central government can know, central government will know what is happening in the state. Means you are agent Vikram of central government. So you will be giving information what is happening in state, and you will be worried for state government or central government. You will be worried for your recruitment. You will be worried for who recruited you. Who recruited you? This example I can tell that yes, center is strong when compared to province or states. Federation with strong, which is technically called as quasi-federal. Which is technically called as quasi-federal. Quasi-federal means not 100% unitary, not 100% federal. Strong center with federal features. Why? Because see, I am not telling center is powerful. Center is powerful only in emergency situations. When emergency situations comes, when something is important, the central government will come up. If not, state will be enjoying its power, central will be enjoying its power. But when the issue comes, who will become the strong? Center. So quasi-federal. What is quasi? English meaning of quasi? What is English meaning of quasi? Look like. It's look like, partial. It look like, seems to be federal but not federal. It seems to be federal but not federal. That is called as quasi-federal. So the federal system of India is copied version of Canada, which is strong center with federal features, which is called as quasi-federal. This is as it is borrowed from. Congruent features borrowed from. Appointment of state governors by the center. Why? Because how I appointed all India services, so that I will be knowing what is happening in the state. I also, this is administratively I will be knowing. Then politically, how I should know? Politically, see, administratively I know. Why? Because you people are working in the state at the district level as a district collector. So what is happening in the district, all information central government will be getting. I also want information from political scenario. Then what I will do? Who is appointing the governor? Center. Central government is appointing the governor. So why that system is there? So if any politically some sections are telling we want to divide from the country, if the state government chief minister is making a conspiracy, why we should listen to central government? We will only form one government. We will only form central government. We will only form one country. Why we should stay with India? If such a sort of conspiracies are made politically, there is a political head called as governor who is appointed by. So he will be reporting to. So what is ensured because of which? Union of India. So strong center with federal features. Governor, appointment of state governors by governor is also taken by Canada. Why? Because my feature is what? Quasi-federal. Why this feature? Because union of states. I want to keep my country. Residual powers. What is this residual powers? I told you, union list, union government can make the laws. State list, state government can make the laws. Congruent list, both. Center and state both can make the laws. What is this residuary? If something is left out. In 1950, as I told you earlier also, in 1950 there is nothing called as cyber security. In 1950 there is no concept of called as information communication technology. In 1950. So if anything new concepts are evolving, if anything new things are coming up, then it is called as residual powers. So all the residual powers will be under the control of central government. All the residual powers will be under the control of central government. Residual powers are controlled by central government. This we copied from Canada. Advisory jurisdiction of Supreme Court. If I want some Supreme Court judgment, Supreme Court advises what I have to do in this context, what I have to do in this context. So advisory jurisdiction also there of Supreme Court, which is also borrowed from Canada. This is very, very important. So Government of India Act, Federal, Governor, Judiciary, Public Service Commission, emergency provisions, all the administrative details. British parliamentary government, prerogative writs, bicameralism, legislative procedure, single citizenship, cabinet system, rule of law, parliamentary privilege. USA, independent judiciary, fundamental rights, judicial review, president impeachment, removal of Supreme Court and High Court, post of vice. Coming to Irish, directive principles of state policy, nomination of members to Rajya Sabha, methods of election of president in Irish. Canada, federation with strong center, which is called as quasi-federal, appointment of state governors by the center, residual powers, advisory jurisdiction of Supreme Court. Very, very important. Read for 1 minute, I will ask now. There is something called as independent judiciary, means judiciary will be acting independently. If I am a judge, I want to give judgment independently, or I should give judgment according to the wish of the government or according to the wish of one of the petitioner. I have to give judgment independently. There is something concept called as committed judiciary. This, whenever the word which comes committed, by default you have to understand, the committed is a word which is used with government. Committed bureaucracy, if you are IAS officer, whatever may be the government of the day, you are committed to the government. You should follow the rules of government. Center, you have to follow. State, you have to follow. Both, you cannot deny central government, you cannot deny. Why? Because you are the employee of state as well as center. So you are committed to the government. It's called as committed bureaucracy. Bureaucracy means IAS officers. This system is called as bureaucracy. Committed bureaucracy. And similarly, there is another terms, prelims 2020 question. This is committed judiciary. A lot of people got confused. 2021. Committed judiciary. Committed judiciary means judiciary. Whenever I told you whenever the word committed is there, committed with government. Committed judiciary means judiciary is committed to. It is negative or positive. Judiciary should not commit. Judiciary should commit only to the constitution. Judiciary should commit only to the constitution, but committed judiciary means judiciary is committed to the government. Means compulsory you will be giving the judgments which is pro for government. That is called as committed judiciary. Committed legislature also. Parliaments. So when they are discussing any law, or when they are discussing any budget, when they are discussing anything which in the parliament, it should be neutral. It should not be towards the government. Committed legislature is also not good. Committed judiciary is also not good. But committed bureaucracy is accepted. Why? Because the IAS, IPS officers are the servants of the government. So you have to work for the government of the day. It's a blend of rigidity and flexibility. It's a blend of rigidity and flexibility. Blend of rigidity and flexibility. Mainly constitutional laws. Rigid constitution. Indian constitution is called as rigid constitution. Indian constitution is also called as flexible constitution. How? I will tell you. Listen carefully. This is a little bit confusing. Rigid constitution. Special procedure for amendment, America. Rigid constitution. Special majority. In the Lok Sabha, 2/3 members of the MPs present and voting. If it is passed, it is called as special majority. The same 2/3 of the members present and voting, if they pass, it is called as special majority. Not only that, 50% of the states should give their approval in their assembly with simple majority. 3 parts are there. First part is in Lok Sabha. For example, in Lok Sabha, if 100 members are present, if Lok Sabha capacity is 100 members and 100 members are present. So if I want to make a Rajyanga constitutional amendment, Rajyanga Savarna, constitutional amendment, then what I will do? Out of 100, 2/3 means how many? 66. So 67. 2/3 plus 1, 67. So 67 members should give its approval. You tell me, out of 100 members, getting 67 is tough or not? Getting 51 is easy. 51 is called a simple majority. And 2 by 3rd majority is called a special majority. All the constitutional amendments acts will happen of special majority in Rajya Sabha also. With special majority. If I want to amend the constitution, then it should happen by special majority. Both got passed with special majority. Very tough. Lok Sabha passed, Rajya Sabha passed. Then this constitutional amendment bill will go to the 50 state assemblies. If it is America. If it is India, 29 states it will go. In that 50% of the state means 15 states. They should also put in their assembly, but simple majority means out of 100 members, how many votes? 51 votes. Now you tell me 2 by 3rd plus 50% of the states should pass in the state assembly. Rigid. Very tough. Why they made it? So the constitution is very sacred. So constitution should be adopted. Constitution should be amended when it is really very, very important. If not simple, you cannot. So when you want to amend, that situation should come. If there should be a dire need of amendment, then only you have to go for. So we made our constitution as what? Flexible also. Flexible constitution. As same as ordinary laws made in Britain. Ordinary law. I told you Constitutional Amendment Act. Understand this. Anyhow, in detail I will be discussing later. This is with respect to constitutional law. In Britain, there is no codified book. So every law will be called as constitution. Every law will be called as constitution. Not only law. Every judgment is also part of constitution. So if I want to amend in Britain, so what I have to amend? I have to amend ordinary law. What is the procedure for ordinary law? State's approval is not required. You tell me. So when I am making constitutional amendment rigid in USA, this is where USA model. When I am making constitutional amendment of unwritten constitution of Britain amended, all the laws are called as unwritten constitution. So what is the procedure? 1 by 2. What is the procedure? 1 by 2. So by this I am telling British constitution is flexible and USA constitution is. In India, this model is present, this model is present. When we are making normal law, we will follow simple majority. When we do constitutional amendment, we follow special majority. So by this, I came to a conclusion that, so Indian constitution is a blend of rigidity and Indian constitution is a blend of both rigidity and flexibility. Article 368 and 2 types of amendments, some provisions, see again, when I go deeper, you will understand that. But 2 provisions will be there. Lok Sabha, Rajya Sabha, 2 by 3rd, plus 50% of the states. When means, when some state is getting, when the states are getting impacted, then compulsory it should be getting approved from 50% of the states. But if any constitutional amendment act, if states are not getting impacted because of that, then there is no requirement of 50% of the states giving their assent. So 2 types of constitutional amendments acts are there. One, when the states are getting impacted, then 50% of the state assemblies approval is required. When the states are not impacting, for example, I am amending fundamental rights, states will be impacted. When I am amending fundamental rights, states are, when I am amending intercourse, commerce, trade, states are getting impacted. When I am making a law on, like governor, when I am making a law on, the better example would be, when I am making a law on Union of States, for example, I am writing like this. Constitution 1, Article 1, Article 2, Article 3. Article 1 is India, Union of States. Article 2 talks about who are the part of India. Article 3, it's a Bharat. Just I am changing the name of Bharat. Now I want to make the name of India in the constitution not as India, like Hindustan I want to change. So by changing name, whether any state is getting impacted? By changing name, any state is getting impacted, not required. For that, 2 by 3rd in the Lok Sabha, 2 by 3rd in the Rajya Sabha. But if state is getting impacted, 2 by 3rd in the Rajya Sabha, 2 by 3rd in the Lok Sabha, plus some provisions, special majority of the parliament, that is 2/3 majorities. Like changing the name of the country. By changing the name of the country, nothing, state is not going to get any impact. Some other provisions, special majority plus ratification by half of the total states. Means ratification means in the assembly they have to pass it with simple. Some provisions can be amended by a simple majority of the parliament in the manner of ordinary legislative process, which don't come under Article 368. So parliamentary act, I am amending a ordinary legislation. By this amendment of ordinary legislation, I am telling that it's flexible. By amendment of the constitution, I am telling that it is. So when I am amending ordinary law, it is called as flexible. When I am amending the constitution, it is called as rigid. So it's a blend of rigidity plus, it's a blend of rigidity and flexibility. Federal system with unitary bias. Federal system with unitary bias. In India, central government is not supreme. In India, state government is not supreme. But there is a provision, central government will also become supreme. There is a provision, central government will also become supreme when there is emergency type of situation. When there is a very big law and order problem, then the central government will come and it occupies emergency situation. 1976 to 1978. At the time of China War, 1962, national emergency. Federal system. Only at that situation, India will become unitary. If not, in normal conditions, we are federal. In normal condition, federal. Sir, what is this federal? Federal, you are telling. Federal means central government is also having powers on some subjects. State government is also having powers on some subjects. Local police controlled by state government. Agriculture controlled by state. Defense controlled by center. In that way, if proper division of powers is there between the central and the state, it is called as federation. That particular system is called as federal system. Federal features. Two governments, division of powers, written constitution, supremacy of constitution, rigidity of the constitution, independent judiciary and bicameralism. Non-federal features means if these are present, two boxes I made. Two boxes. It should be on your tip. We will think I already read it, but no. We have to produce quickly. When I will call any country as a federal country, when I will call any country as a federal country, number one, two governments are present. What are the two governments? Center and state. Division of power. What is the division of power? Union list and state list properly. These are the union list, these are the state list. On the union list, union government have the power. On the state list, state government have the power. Written constitution, everything is written. No confusion. These are the things for the central government, these are the things for state government. Everything is written. If it is not written, there will be abstract, confusion. Supremacy of the constitution. It is not the central government supreme, it is not the state government supreme. Everyone should follow what? Constitution. Already constitution is a written document. So there is certainty, there is a clarity. When certainty and clarity is there, what we can ensure? Federal features. Rigidity of the constitution. Now the if the central government is having the power, see, everyone want to have a unitary power. If Narendra Modi is there, he want more powers. Now, yesterday he came to Hyderabad. What happened? The state chief minister did not meet him. And state chief minister gave lot of criticism on him. So in his mind, he will be having this feeling, I had power, I will crush this government, state government. So that feeling will be there for every central government. But if that feeling is there, and if I destroyed this state government by using defense forces, then there is nothing called as federal, everything is becoming unitary. So what I did, by law if I want to make, I am making a constitutional amendment act and I am telling that now onwards India is not called as federal, India is called as unitary country. So it is passed in Lok Sabha because it has majority. It passed in the Rajya Sabha, it has majority. But states are getting impacted. Then where it should pass more? 50% of the states. Why 50% of the states will accept? It might be the BJP government also. Why? Because you are removing the powers of state government. So here rigidity of the constitution is helping to ensure rigid undadam valla what is happening is, as it is rigid, it is becoming tougher to make federal into If not, by the time the Indira Gandhi, not Narendra Modi, by the time Indira Gandhi only used to make it as a independent judiciary. If the judiciary is biased towards central government, so compulsory the central government want to ensure unitary power. So what will happen? Unitariness will come. But independent judiciary is there, and the independent judiciary is working according to the constitution. In constitution, unitary is there or federal is there? So independent judiciary is also indirectly promoting what? Federation. And bicameralism. Listen carefully. Bicameralism means two houses are there, Lok Sabha and Rajya Sabha. Lok Sabha is a members of House of People, Rajya Sabha is a House of States. Means Telangana MPs are present, Kerala MPs are present, Andhra Pradesh MPs are present, Rajasthan MPs are present, Maharashtra MPs are present. All the MPs are present in the Rajya Sabha. That is the reason Rajya Sabha is called as Council of States. So you tell me whether states representatives are present in the Rajya Sabha means whether they will work for the states. So if the central government want to make unitary, why Rajya Sabha will pass? Again, in detail I will explain you in Parliament, but still I will tell you now. Lok Sabha, the country is divided into constituencies. One constituency. Like this, the country is divided into constituency. The people who are present in the constituency are electing their representatives. So that means people's representatives are present in Lok Sabha. So that is the reason I am calling it as states. Here, people's representatives will not be present in Rajya Sabha. State representatives will present in Rajya Sabha. Means state MLAs will be electing one person or two person according to the number they have. They will be sending it to the Rajya Sabha. If there is a constitutional amendment in the Parliament and BJP government is having majority in the Lok Sabha, for example, they have 400 MPs, huge number. So compulsory by 2/3, it will pass. Chance of becoming unitary became true now. Why? Because it passed in Lok Sabha by 2/3 majority. But when it comes to here whose representatives are present? State government's representatives are present. State representatives are present. And this Constitutional Amendment Act is telling that now onwards, there is no federal features. Now onwards, why the state representatives will vote here? When you are my friend, when you respect me and when you give me power. When you don't respect me and you want to eliminate me, then how I will become your friend now? Why? Because you are completely eliminating now. Federal is becoming unitary. So this Council of State, obviously they will not vote. So this is also one mechanism which is ensuring. This is also one mechanism in mains point of view. Today's answer writing, read this question. What are federal features of the Constitution? What are federal features of the Constitution? This is mains, final question only. In this same simple questions they will ask. What are federal features of the Constitution? Full stop. How these federal features are ensured? How these federal features are ensured? Question mark. 15 marks, 200 words, means 3 pages. First you will write about federal features is a salient provision of Indian Constitution. Federal features, there will be unitary government as well as the state government. So what are the features of the federal government? 2 governments, center and state. Division of power, there is a clarity. These all you will be mentioning. Bicameralism, supremacy of the Constitution, independent judiciary and written Constitution, rigidity of the Constitution. These all are ensuring what? If these are not there, what will become? Unitary means what? Non-federal. What are non-federal? Unitary. A strong center. Single constitution. Everyone should follow one constitution. Single citizenship. Everything is single. Single constitution is there. Single citizenship is there. Why we want 2 governments? We will have only one government. No. Unitary will tell that when only single citizenship is there, only single citizen constitution is there, then why we want 2 governments? We will abolish governments of state. No Jagan Mohan Reddy, no KCR, nothing, no one will be there. Only one person will be there. So, non-federal features means unitary features. If there is a strong center, if there is single constitution, if there is single citizenship, and if there is a chance of flexibility of the constitution, there is a chance of removing federal feature into unitary feature. Flexibility of the constitution, integrated judiciary, High Court to Supreme Court. High Court is in every state. So now onwards what? High Court is also there, but the final authority is Supreme Court if I tell. And the Supreme Court is working according to the wish of central government. Finish. We can finish off the state governments. Appointment of state governor, he will be working for central government. All India services, you people will be working for central. At the time of emergency, it is going to become. So if these are there, then obviously it is unitary. Federal is becoming non-federal. Federal is becoming non-federal. If these are there, it is called as federal. If these are there, it is called as non-federal or unitary. Term federation has nowhere been used in the constitution. But that very important. I am using the federation word, which is the meaning. But in reality, the federation word is nowhere used. India is called as Union of States, but not Federation of States. Article 1 describes India as a Union of States, which implies two things. One, Indian Federation is not the result of an agreement. We didn't make any agreement like America made. By instinct, we came together. And two, no state has the right to secede from the Federation. We are not allowing. If Khalistan, Punjab people are telling that we want Khalistan, no, we will not leave you. If Nagaland is asking for, we want Greater Nagaland separate country, no. Jammu and Kashmir asking for Azadi Kashmiri, no, we are not going to leave you. So it's a union of state with strong center, and with strong center means here the meaning is becoming one. Union, together. Secession means division we are not going to allow. We are not going to allow division of our state from the country. Description of Indian Constitution, federal in form but unitary in spirit, which is called as quasi-federal. Who told that? Unitary, federal in form, but unitary in spirit. Why unitary in spirit? In emergency times, in governor role, all India service, it is unitary in form. But spirit is, state is also there, center is also there. Federal in form, but unitary in spirit. Who told this? K.C. Wire. Who is he? He is a constitutional expert of Britain. He tells that India is quasi-federal. Why? Because federal in form, unitary in spirit. Bargaining federalism, Morris Jones. Cooperative federalism, Greenwell Austin. Center and state. Give me some funny. State government will ask or not. Then central government tell that a bill is not getting passed in Rajya Sabha, tell your MPs to pass it. Then they will tell to pass. So a bargaining, a cooperative federalism. Federation with centralizing tendency, divergence. Federation, but more tilted towards a federation, more tilted towards unitary bias or more tilted towards centralization. So we will tell that India is not 100% unitary, not 100% seems to be federal, but not federal. That seems to be federal is called as quasi. So federal system with unitary bias, conclusion is, see, this is the concept. Questions will be framed on this only. If you understand this unit also, you get a grip on constitution. At least this 17 salient provisions, if you understand properly, you will get grip. Governor will work for central government or state government with what you are seeing in the news daily. Why he will work? Why? Because he is appointed by so he is trying to make unitary. The state governor and the state government chief minister, they will not see each other. If the governments are different, like if it is in center, it is BJP, and if it is state, it is Jagan Mohan Reddy or KC or any other person. They won't like governor. Why? Because governor will be working for governor. All India service also they will not like. Why? Because finally this IAS officer, IPS officer is the final recruit, is employee of central government on. So it seems to be federal, but most is unitary. Federal in form, unitary in spirit. These names you have to remember for your mains, like K.C. Ware. In this answer you can write this. According to K.C. Ware, it is federal in form but unitary in spirit. Bargaining federalism, according to Morris Jones. According to cooperative federalism, it is Greenwell Austin. According to federation with a centralizing tendency, according to Ivor. Any one you remember. You cannot remember 4, remember 1. Best this one. Federal in form but unitary in spirit, which is also called as quasi-federal. Who told this? Separation of powers means simple. Central list, state list. In this list, central government is having the powers to make the law. or central government is having the powers to make the policies. State list. Central government will be having the powers to make the laws, or central government is having the power to make the policies in this central list. Division of power. That is different. That is separation of powers. This is division of powers. Division of powers. Independent judiciary. Independent judiciary means here, independent judiciary means I am acting without government, not towards central government, not towards state government. Separation of power is state. State is divided into 3 units: executive, legislature, and judiciary. Here separation means one should not interfere into other, that much. Legislature should not interfere into the judiciary, executive should not interfere into the judiciary. That is called as separation of powers. So 3 are separate. Judiciary is one wing, executive is one wing, legislature is one wing. They have to act independently. With respect to country as a whole, division of power means independent judiciary. Here I should not tilt towards central government, here I should not tilt towards state government. I have to give the judgment, division of power. There are some subjects in which central government will be making the laws. There are some powers, some list which are state government is, that is division of powers. Separation of powers is a big word. Division of powers within the available, we are dividing it. Parliamentary form of government, I am telling slowly. Why? Because this is concept. This is the original concept. If you understand this, then rest of will be easy. Tomorrow, parliamentary form of government. What is this parliamentary form of government? Synthesis of parliamentary supremacy, sovereignty, and judicial supremacy, integrated independent judiciary. This we will be dealing. Yesterday's test papers you will be getting by 3 days.